dear audience, welcome to 2021 World Intellectual Property Forum, the online virtual conference. I'm the moderator, Professor Mei-Hsin Wang from National University of Science and Technology, Taiwan. I'm the Fellow Royal Society of Chemistry UK. I'm here for the panel titled Controversy and FRAND for Standard Essential Patent in Court. In this panel, we are very honored to have Sir Christopher Floyd, the former Law Justice Appeal, UK Court Appeal, England Wales, Honorary Professor of Law from University College London, and Professor Randall Rader, the former Chief Judge of United States Court of Appeal for the Federal Circuit and the Rader Group. Professor George Thomas Floyd, the presiding judge of Germany Federal Patent Court, and Dr. Joseph Kim, the former Chief Presiding Administrative Judge, IPTAP, Korea Intellectual Property Offices, to share their views on the panel titled Controversy and FRAND for Standard Essential Patent in Court. Our first speaker is the former Law Justice of Appeal UK England Wales, the Honorary Professor of Law, Faculty of Law, University College London, Sir Christopher Floyd. Your Honor, highly appreciated for joining this panel. Upon the non-stop improving and emerging technology, standards can be beneficial for everyone because once the standards are chosen, the industry supply chain may enjoy the simplified choice for manufacturing new products and services, while the consumer could also be indulged with the less expensive product and services in a faster manner. However, patent system is meant to promote innovation, while the standard setup could somehow otherwise, if the law and policy are not carefully regulated. There are always controversies upon essential standard patents and its licensing principle, people call FRAND, fair, reasonable, and non-discriminated. There are several controversies. People say standard essential patent will hinder the licensing. People assume the SEP owner will raise the royalty rate to hinder the market competition. Some people argue whether FRAND is really necessary if the total accumulated royalty for a specific technology is always high and standard setting organization may weaken the enforcement of the FRAND. Nevertheless, certain terms of the licensing are required to be disclosed. Therefore, why bother to employ FRAND for SEPs? May Your Honor kindly share your views on above controversies.
Professor, and good day to everybody. I'm very privileged to be here at this important conference. If we can look at my first slide, this is what I am going to talk about briefly with you this morning. In the courts in England and Wales, we've had a number of quite big cases in which not only have people been seeking to enforce standards essential patents, but they have also been seeking to involve the courts in the settling of the terms on which a FRAND license can be granted. And we've had a big debate about whether that license should just be a national patent or a national patent license or a global patent license. So we have now got a bit of experience under our belts, and I wanted to explain in general the problems which are faced by us, and also suggest an approach as a way forward as to how national courts might avoid competition between themselves and assist industry in settling these disputes, which can otherwise prove very costly and take a long time to resolve. So in this slide, I briefly set out what the problem is. Everybody, I think, agrees that the system under which global standards for telecommunications are arrived at by International Standard Settings Organization has made really tremendous technical benefits available to the public. So in general, the system, that system is working very well. But intellectual property has proved to be something, as it often is, as of an obstruction because of two things, really. The innovators, the people who make the inventions and propose them to the standards setting organizations, want to get some reward for their contributions. They want to have incentive to come up with good ideas and good technical solutions, and want to be able to charge royalties to implementers. Implementers sometimes are reluctant to pay the sort of royalties which innovators want. And it's generally agreed that innovators should not be able to hold up the adoption of the standard by charging unreasonable royalties for use of their inventions. And on the other side of the equation, implementers ought not to have free access to the market without paying at least something for the use of the invention. So that is the problem which the industry as a whole faced. And it was solved, at least at the outset, and in part, by requiring the innovator to give an undertaking that licenses under any patent which is adopted within the standard as an essential patent, an SEP, should be available on fair, reasonable, and non-discriminatory terms. So that gets over the first part of the problem, that implementers can't be held up, and they may use the inventions which are built into the standard, provided they pay the FRAND royalties. But the one thing that these standard setting organizations neglected to think about when they came up with this solution to the first part of the problem is who decides, because you would be an optimist, to say the least, if you thought that implementers and innovators were going to agree on the question of what is a fair, reasonable, and non-discriminatory royalty. Now, normally, and I'm sure there are lawyers amongst the audience, normally when somebody drafts an agreement which says something like the parties will agree on reasonable terms, they realize that they're drafting a clause which is somewhat uncertain, unless they include a definition, which none of these agreements do, unless they include a definition of what is meant by reasonable terms, then the clause is desperately uncertain, because it does not provide a means for working out what reasonable terms are in default of agreement. And anyone who's read any number of contracts in the property field, for example, will see that you draft clauses which say a reasonable sum to be settled in the absence of agreement by arbitration or by the president for the time being of the chartered institute of whatever it is the appropriate field to be setting such things. So you have to provide a mechanism, and people who drafted all these FRAND undertakings did half the job by making sure that there was access to the technology, but they didn't do the second half of the job. And they've left it for the industry and the courts and anybody else who gets involved to try and work out a mechanism for deciding what is FRAND. So if we could look at the next slide, please. I've set out there the possible approaches of mechanisms to decide what is FRAND. The first one is optimistic negotiation, and the parties sometimes do agree, usually after a bit of litigation, what is FRAND, and they settle. In which case, fine, you don't need any external mechanism. But where the parties don't agree, which is probably in the majority of cases, the first possibility is mandatory arbitration. So building into these clauses, not only an obligation to grant licenses, but an obligation on implementers and those who take advantage of the standard to accept a license on FRAND terms to be settled by a particular arbitration panel, which it would have to define. That's quite a good solution if you can make it legally enforceable, and there are various people who have discussed ways in which that might be done. It has its limitations because the has taken the view that any agreement which, as it were, undermines access to the courts under the regulations governing jurisdiction is not enforceable. So, it's a case called West Tankers, which is a slight. Beyond that, there could be consensual arbitration. The parties could agree on arbitration, but parties that are in opposite interests sometimes can't agree that. And then the only remaining possible, and that's where my experience. Let's look at the next slide. Can we turn the slide over to the next one? Thank you. So when the English courts have been faced with these problems, there's been resistance, it's fair to say, to the national court becoming involved. In favor of the national courts becoming involved, you can say that given that nothing else has worked, the parties haven't negotiated a settlement, there's no mandatory arbitration, they haven't agreed to arbitrate, there's really no choice but to go to the national court. And a second possible criticism that I haven't put down there, but I should mention, is that judges in general, patent judges, are not economists, they're not experts on licensing. They have to be reliant very much on the evidence given by expert economists, licensing experts, and so on. Whereas you could compose an arbitration panel from people who have a real expertise, not just in intellectual property, but in licensing and the economics, and they could see the whole picture themselves. Beyond that, of course, that if the national courts are becoming involved, you get fights between jurisdictions. You get a rush to one jurisdiction because it's perceived to be generous in the royalty rates that it sets, and a rush by implementers to another jurisdiction because it's perceived to set lower royalty rates. And last of all, it may result in a court which has little or no real connection with the licensing operation, being the court which sets the royalty rate. And that is what I've called the problem of forum conveniens, that the forum which is not the most convenient forum and not the most appropriate forum ends up setting a royalty which applies in the other jurisdictions where it would be much more appropriate for the courts to become involved. So that last point, I think, is on the next slide. And I've given there a short example. We have a company that makes and sells 90% of its phones in country A and markets them throughout the world. talking about mobile telephones, almost all these cases have been about mobile telephones. And in country B, the X sells phones, but only a very small proportion of the market. His total market for phones is represented by country B, 5% or less. But X is infringing in country B, and country B undoubtedly has jurisdiction over an allegation of infringement of patents held by X in country B. And if sued in country B, X will raise what's called a FRAND defense. He'll say, well, even if I infringe, usually he'll say, patent's not valid, I don't infringe. But if it's valid and infringed in the alternative, then I have a defense based on my the FRAND undertaking. I'm entitled to a license, so you can not get an injunction to stop me being on the market in country B. So the court of that country B, says, yes, I've got jurisdiction to try patent infringement and validity, and yes, I have jurisdiction to try your defenses. Indeed, it would be quite unfair to you, Mr. X, for me to try the patent infringement side of it and not allow you to run your FRAND defense. So that's how this country with a small percentage of the total market ends up deciding on what might be a FRAND license, and possibly a global FRAND license, for the patentee's patents. And that is not satisfactory in a lot of people's view, because the consumers in country A, remember that's where the phones are made and sold, are being requested to, or required to pay royalties set by the courts of country B. And we've seen this in the case of companies like Huawei and ZTE, Chinese manufacturers of mobile phones, not being very happy about the courts in Europe, saying, well, the global rate for this portfolio of patents is so much. So that's the forum conveniens problem, that the perfectly good claim to jurisdiction in these remote countries, but the unsatisfactory result is that the defense and the FRAND license are being adjudicated by what to country X are foreign courts. So then, turning over to the next slide, please. Just a very brief explanation of how forum conveniens works in a traditional case in the UK. It's recognized that if there is some other available forum which has jurisdiction and which is the appropriate forum for the trial of the action, then the appropriate or natural forum should decide the case. And what's the appropriate or natural forum is the one that has the most real and substantial connection. So that includes convenience, where the witnesses are, where the manufacturer is would be another factor, what the governing law would be, and the places where the parties carry on the majority of their business. Now, the problem with that is the sort of case which I've described, where you have a patent infringement action and a defense, is a sort of hybrid case. Half of it is really only triable in the court where the patent is situated, i.e., I've called it country B, which only has 5% of the market, but nevertheless the courts of country A can't try the issues of validity and infringement because they are generally regarded as the exclusive province of the country where the property is situated. On the other hand, the defense, the FRAND license and setting the terms of the FRAND license has a different character. And there you would say, well, the most appropriate forum is not the UK. So this is an unusual problem where some issues cry out for being tried in one country and other issues cry out for being tried in another country. So can you turn that to the next slide, please? And that's really what I've set out here. The only viable forum for a patent infringement and validity is the National Court of Country B. But entitlement to a FRAND license may be more appropriately tried in a country where they have a jurisdiction to decide those sorts of cases. Now, the problems being faced by in some of the decided cases so far is that there was a real dispute as to whether the courts of the foreign country would decide on the terms of a FRAND license between the parties. And the law, I think particularly in China, was in a state of development where no one was prepared to say that the Chinese courts would definitely take on the task which the English court had said it was prepared to take on. But I think that will change in the future, and you will have cases where there is a genuine fight as to whether the foreign court is better situated and the more appropriate and natural court to try that FRAND defense. That's why I put in that last bullet point. If B is the appropriate forum for the claim, but A is the appropriate forum for the defense, could the court split the case into two? So turning over then to, I think, the next slide. The possible approach which I suggest, which would meet quite a lot of the criticisms, would be to leave innovators free to bring proceedings of patent infringement up to the point where validity or invalidity and essentiality, non-essentiality and infringement to be decided. But if the implementer is prepared in those circumstances to accept a license, then the trial of that issue should be in the forum conveniens in the country which has the most real or substantial connection with that aspect of the case. Now, we've not yet had a case where that possibility has really arisen, but it seems to me that that at least is a sensible approach which takes account of where things are best tried and decided. And it will remain to be seen whether the courts are able to develop such a flexible approach in the future. But that was what I had to say on that topic. I think there's a final slide in the pack. Thank you very much.
Yeah, thank you for your honor, very kind and comprehensive explanation for the SEP and FRAND with two cases and a possible approach for the remedy.